The morning they broke ground on the 8th cabin, I was standing at my kitchen window drinking coffee and watching a bulldozer tear through what used to be my grandfather's wheat field. I didn't say a word. I just watched. My neighbor Gerald, the HOA president, was out there in a hard hat, pointing at blueprints, laughing with the contractors, acting like he owned every blade of grass from here to the tree line. He had a logo on his polo shirt. He had a clipboard. He had 31 months of rental income already in the HOA's account from the 7 cabins he'd already built. What he didn't have was a deed. What he didn't know, what none of them knew, was that I was holding one. A legal, county-recorded, uncontested deed to every single square foot those cabins were sitting on. I'm a property attorney. I've spent 19 years doing exactly one thing, watching people underestimate land title law. And I had let this man build. I had watched him build. 8 foundations. 8 roof lines going up on land that had belonged to my family since 1948. Because I needed him exactly where he was, arms deep in concrete and lumber, name on the permits, rental income in the ledger, before I walked into that courtroom. Stay with me, because what happened next cost him everything. My name doesn't matter for this story. What matters is the land. 14 acres on the eastern edge of what is now a planned HOA community called Sunridge Commons. 74 townhomes, a clubhouse with a covered patio, and a nature amenity corridor that someone decided somewhere along the way included a strip of my family's property. I grew up as the son of a farmer and the grandson of an immigrant who purchased those 14 acres in 1948 with cash. 7 years of farm labor saved in a tin box under a bed. No mortgage, no bank, no debt. Just a handwritten deed, witnessed by 2 men who have been dead for decades, describing every boundary of that land down to the inch. I went to law school because my father told me the one thing that could take land from a family faster than drought or debt was a piece of paper they didn't understand. So I learned to understand every piece of paper there was. When Gerald Marsh became HOA president in 2011, I watched him the way you watch weather. Not with fear, with attention. Because men like Gerald don't stay still. They expand. They improve. They develop. They plant their logo on things that don't belong to them and wait to see if anyone pushes back. I pushed back. Just not the way he expected. I pushed back with a 1948 deed, a 47-page title report, a licensed surveyor's GPS coordinates, and 19 years of knowing exactly what happens when someone builds a permanent structure on land they don't own. But to understand why I waited, why I let him pour 8 foundations before I said a single word, you have to understand where this land came from. And that story starts long before Gerald Marsh ever pulled on a hard hat. My grandfather's name was Dimitri. He came to this country in 1941 with $40, a suitcase, and a working knowledge of wheat. He didn't speak the language well enough to negotiate, so he didn't negotiate. He worked. 7 years on other men's farms, dawn to dark, cash wages, tin box under the bed. He sent nothing home because there was no home to send to anymore. He saved everything. And in the spring of 1948, he walked into the county recorder's office with a cashier's check and walked out with 14 acres of eastern boundary farmland that nobody else wanted because the soil was rocky and the creek flooded every March. Dimitri didn't care about the flooding. He knew how to build a dam. I have the deed framed in my office. It's handwritten in the particular slanted cursive of a county clerk who clearly took pride in his penmanship. It describes the parcel in metes and bounds, old surveying language, compass bearings and chain lengths, and it names every boundary with the kind of specificity that only matters when someone tries to take what's yours. 190 feet along the eastern boundary, bounded by the dry creek to the north, the stone wall to the south, and everything in between. Everything in between. He built the farmhouse himself, over 2 summers, with timber milled from trees he cleared from the northern edge of the property. It's not a beautiful house. It never was. It's a practical house. Low ceilings, thick walls, small windows set deep into the stone to keep the cold out. The kind of house built by a man who understood that shelter was not an aesthetic statement. It was a declaration of permanence. My grandmother arrived in 1950. She stepped off a bus, looked at the house, looked at the rocky field, looked at Dimitri, and said something in their language that I was told as a child translated roughly to, "Well, it's ours." The first thing she did, before she unpacked, before she cooked a single meal, was plant a tree, an apple tree, on the eastern edge of the property, facing the morning sun. Over the next 11 years she planted 43 more. Apples, pears, 2 plum trees, and 1 ancient fig that had no business surviving winters that cold, but somehow did, every year, out of what I can only describe as stubbornness. By 1961, the orchard ran the full length of the eastern boundary. A living fence, she called it. Something that gave fruit and marked ground at the same time. I grew up in that orchard. I know the specific give of soil under those trees after a rain. I know which branches the light hits first in the morning and which ones still hold frost at noon. I know the sound the creek makes in March when the snowmelt comes down fast and the water pushes against the stone dam my grandfather built by hand, a low, constant rushing sound, like the land itself exhaling. My father took over the property in 1979. He farmed it modestly, wheat, some corn, a kitchen garden my mother ran with military precision. He declined 3 separate purchase offers over the years, including one in 2006, from a developer named Carver Holdings who wanted the eastern acreage for residential amenity expansion. My father's response to that offer was brief and entirely unprintable. I came back to the land in 2009 after my father's first health scare, and I have been here since. I converted the barn into a workspace, transferred the farming to a neighbour who leases the western fields, and settled into the farmhouse with my wife, and eventually 2 children who now know this land the way I knew it, by feel, by season, by the specific sound of that creek in March. This is the land Gerald Marsh decided to build on. Sunridge Commons broke ground in 2007 about a quarter-mile west of our property line. I remember watching the first earth movers from the barn roof. Orange machines turning what had been scrubby pasture into graded lots with survey stakes every 20 feet. It wasn't alarming. Development happens. People need houses. I noted that the planned community's eastern boundary appeared to run close to our fence line, made a mental note to review the plat when it was recorded, and went back to what I was doing. I reviewed the plat in 2008 when it was filed with the county. I noted the boundary descriptions. I noted that the HOA's surveyed eastern line ran 190 feet along what they labelled common land, nature corridor. I noted that this measurement matched, almost exactly, the western edge of my grandfather's 1948 deed. Almost exactly. There was a 0.3 acre discrepancy. A thin strip, 190 feet long and roughly 70 feet wide at its widest point, that appeared in my deed's legal description, but did not appear in the HOA's recorded plat. It wasn't labelled. It wasn't accounted for. It existed in the gap between 2 surveys conducted 60 years apart by 2 different surveyors using 2 different methodologies. I flagged it. I made a note. I did not immediately act, because at that point the strip was vacant land, a weedy buffer zone between my orchard and the HOA's landscaped corridor. No structures. No use. Nothing that demanded urgency. I watched. Gerald Marsh was elected HOA president in 2011 by a margin of 31 votes to 12. I know this because HOA elections in a community of that size are public record. I know Gerald's margin because I pulled the minutes. I pull a lot of records. It's a professional habit that has, over 19 years of practice, saved more clients than any argument I've ever made in a courtroom. Gerald was a retired sales executive, medical device industry, mid-tier management, the kind of career that ends with a plaque and a handshake and a pension, just comfortable enough to fund a very active retirement. He moved into Sunridge Commons in 2010 and within 8 months had joined the HOA board, reorganized the landscaping committee, and introduced a colour-coded violation notice system that he described, in the board meeting minutes I later read, as streamlining community standards enforcement. He had business cards made. They said Gerald Marsh, community president. The word president was in a slightly larger font than everything else. I know this because he handed me one at our first meeting, and I still have it. He referred to my property, in board meeting minutes, in HOA newsletters, in casual conversation with neighbours, as the East Boundary Parcel. Not a farm, not a residence, a parcel. Something to be managed, buffered, eventually absorbed. In 2014, he proposed the first version of what he called the East Amenity Corridor Improvement Plan, a scheme to convert the nature buffer along the HOA's eastern boundary into rentable retreat cabins for HOA members. Small cabins, he said. Tasteful. Revenue generating. An asset for the community. The board approved it 4-1. The one dissenting vote came from a woman named Patricia, who noted in the minutes that the Eastern Boundary Survey should be independently verified before any construction is authorised. Patricia was voted off the board in the next election cycle. Gerald reorganized the nominations committee shortly thereafter. By 2017, when I sat down with my grandfather's estate documents to transfer the deed into a family LLC for estate planning purposes, Gerald had been quietly preparing his Cabin Row development for 3 years. He had architectural drawings. He had contractor bids. He had a phased construction timeline. What he did not have, what his reorganized board and his color-coded violation system and his business cards with the large font president had not bothered to secure, was a clean chain of title to the land he intended to build on. I discovered this on a Tuesday afternoon in March, sitting at my desk with a cup of cold coffee and a stack of documents going back 70 years. I sat very still for a long time. Then I picked up the phone and called a title examiner I trusted, a woman named Ruth, who had been tracing land records in this county for 30 years, and who had, on more than one occasion, found exactly the kind of error I was now staring at. I described what I'd found. There was a pause on her end. "How long has the HOA been treating that strip as common land?" she asked. 9 years, I said. Another pause. "And they haven't filed for adverse possession?" "No," I said, "because they don't know the strip isn't theirs." Here's what you need to understand about adverse possession, because it matters to this story. In most states, a party that occupies another person's land, openly, continuously, and without the owner's permission, for a statutory period of between 10 and 21 years, can potentially file a legal claim for title to that land. It's an old doctrine, originally designed to settle frontier boundary disputes, and it still exists in every state in the country. The key word is statutory period. In our state, that period is 20 years. The HOA had been on the strip for 9 years when I found the error. They needed 11 more. I had absolutely no intention of giving them 11 more years. But I also understood something that Gerald, in his polo shirt and his hard hat and his phased construction timeline, did not. Patience is not the same as passivity. I could assert my rights immediately, file a quiet title action, get an injunction, stop the construction before it started. Or I could wait. Document everything. Let Gerald build. Let him sign permits. Let him generate rental income. Let the encroachment deepen and the paper trail thicken and the unjust enrichment grow until the moment I walked into court with not just a deed, but a damage figure that would make a judge's eyebrows rise. I chose to wait. I made myself a second cup of coffee. I called Ruth back and asked her to prepare a full title report, comprehensive, documented, suitable for litigation. And then I went outside and walked the eastern boundary of my grandfather's land, all 190 feet of it, in the long afternoon light, the orchard to my left and the HOA's nature corridor to my right, and I thought about a man who came here with $40 and a tin box and built something that was still standing 80 years later. "Well," my grandmother had said when she first saw it, "it's ours." It still was. Spring came early that year. I remember because the creek flooded 2 weeks ahead of schedule, and I spent a Saturday morning reinforcing the stone dam with my older son, the two of us knee-deep in cold water that hadn't yet decided whether it was winter or not, stacking rocks the way my grandfather had taught my father and my father had taught me. There is a particular satisfaction in that kind of work, physical, purposeful, passed down through hands rather than words. When we finished, my son stood back muddy to the hip and looked at what we'd built with the serious authority of a 9-year-old who has just done something real. "Grandpa Dimitri would like that," he said. I told him I thought so too. 2 weeks later, I stood at my fence line and watched a crew of contractors drive survey stakes into the ground 40 feet from my orchard. Gerald had begun. The first foundation pour happened on a Wednesday morning in April 2019. I know the exact date because I photographed it. Time-stamped, GPS tagged, filed in a folder on my desktop labeled simply Marsh. I stood at my kitchen window with my coffee going cold in my hand and watched them mix the concrete, watched the forms go in, watched Gerald walk the site in a hard hat, gesturing at the tree line with a rolled blueprint, speaking with the easy animation of a man who has confused authority with ownership. He was laughing at something one of the contractors said. That detail has stayed with me. The particular sound of a man laughing on land that isn't his. A white envelope arrived in my mailbox 3 days later. HOA letterhead, formal language, the careful, passive voice of institutional correspondence. It informed me, as a courtesy notification, that Sunridge Commons HOA was undertaking scheduled amenity improvements to the Eastern Common Land Corridor, and that as an adjacent property owner I might notice temporary construction activity in the coming weeks. It thanked me for my patience and wished me a pleasant spring. I photographed the letter, noted the date, and filed it in the Marsh folder. I said nothing. I let them build. Over the following 6 weeks, cabin 1 went up, then cabin 2. The framing was fast, prefabricated panels, a crew that clearly knew the system, a rhythm of delivery trucks and nail guns that became the background noise of my mornings. Gerald was on site most days, clipboard in hand, moving between the construction zone and the HOA's walking trail with the proprietary ease of a man conducting a tour of his own estate. By June, 2 cabins had roof lines. By August, they had windows and doors and a gravel path connecting them to the main trail, lined with the kind of ornamental grasses that cost 3 times what functional plants cost and exist purely to signal that someone has paid attention to aesthetics. By September, they were listed on the HOA's member rental portal at $180 a night. I noted the rental rate. I filed it. I opened a spreadsheet and began tracking dates, occupancy estimates based on the portal's availability calendar, and projected revenue. It was the kind of meticulous, unglamorous work that wins cases. Nobody photographs the spreadsheet. But the spreadsheet is what the judge reads. The first violation notice arrived in October. After 12 years of living on this property, 12 years of the same fence, the same barn, the same orchard my grandmother planted in 1961, I received a printed HOA violation notice informing me that my perimeter fence was in non-compliance with community height standards. The fence is 4 feet tall. It has been 4 feet tall since 1974. It was built by my father using timber from trees he cleared himself, and it has stood through 45 winters without complaint from anyone, including, for the first 12 years of its existence, the HOA that was now citing it. I stood at the kitchen table and read the notice twice. My wife was at the counter behind me. I didn't say anything, and neither did she, because we both understood, without discussing it, what this was. This was not a genuine code enforcement action. This was Gerald letting me know that he had noticed me noticing him. This was a message dressed up in HOA letterhead. I responded with a certified letter. Not through the HOA's internal dispute process. I had no intention of engaging with Gerald's machinery on Gerald's terms, feeding documents into a system he controlled and that would simply lose them. My letter was addressed directly to the HOA's registered legal entity, documented the fence's construction date with a photograph from my father's records dated 1974, noted that the structure predated the HOA's recorded CC&Rs by 33 years, and stated clearly that I considered the violation notice both void and retaliatory. I kept a copy. I sent it certified mail, return receipt requested, and filed the green card when it came back. The second violation notice arrived in December. Unapproved landscaping. The specific landscaping cited my grandmother's orchard. I want you to sit with that for a moment. An orchard planted in 1961, 60-year-old apple and pear trees, a fig tree that had outlasted 2 generations of my family, a living fence my grandmother said would outlast any argument about where the land ended, cited for non-compliance with landscaping standards written in 2008. I stood at the kitchen table and read that notice with a particular kind of stillness that I have learned over 19 years of legal practice to recognize in myself. It is not anger exactly. It is closer to clarity. The absolute cold clarity of a person who now knows with certainty what they are dealing with and exactly what they intend to do about it. Same response. Same folder. Same green card filed when it came back. Here is something most homeowners don't know, and something Gerald almost certainly didn't know about me specifically. In many states, HOA fines and violation notices issued against pre-existing conditions, structures, landscaping, or land uses that existed before the HOA's CC&Rs were recorded, are legally unenforceable. The doctrine is rooted in the same logic as non-conforming use protections in municipal zoning law. If your fence was standing before the HOA existed, the HOA cannot retroactively impose its standards on that fence. If your orchard was planted before the covenants were filed, those trees are not subject to landscaping rules written decades after they went into the ground. The HOA's authority runs forward from the date of its formation, not backward through history. Gerald was issuing fines he had no legal authority to collect. He was also, with every notice he sent, handing me another brick for the retaliation case I was quietly building around him. The notices kept coming through 2020, arriving with the regularity of a subscription nobody asked for. February. Visible agricultural equipment. A hand plough stored behind my barn, partially visible from the HOA's walking trail on clear days, if you were specifically looking for something to complain about. A plough that had been in that barn since my father's farming years, rusted at the blade, kept not for use but for the same reason families keep old tools, because throwing them away feels like throwing away the person who used them. April. Noise disturbance. A rooster. A single rooster, kept entirely within county ordinance on agricultural land that had housed livestock continuously since 1952. I pulled the county code, confirmed the ordinance, attached it to my certified response, and filed the whole exchange. July. Exterior paint condition. My farmhouse exterior, which had last been painted in 2004 and was, I will admit, showing the dignified weathering of a working farmhouse rather than the fresh coat perfection of a planned community. It had never attracted comment in 12 years. It attracted comment now because Gerald needed it to. 5 violation notices across 14 months. Total fines levied, $4,200. I did not pay a single cent. I responded to each one with a certified letter, documented, dated, filed. The Marsh folder had become a thick accordion of paper organized by date, each document cross-referenced to the spreadsheet tracking Gerald's cabin revenue on the other side of my fence. 2 parallel records growing simultaneously. One was Gerald's case against me. The other was mine against him. Only one of us knew both records existed. Then he put up the camera. In August 2020, a HOA maintenance crew arrived at the boundary fence with a metal post, a concrete anchor, and a weatherproof housing that Gerald described in the community newsletter as a community security enhancement, part of our ongoing commitment to resident safety and property protection. The camera was positioned, with a precision that could not have been accidental, to point directly at my driveway and the front face of my barn, not at the HOA's walking trail, not at the cabin row, at my property, at my daily movements, at the barn where my children played on weekend afternoons. I looked up the relevant statutes. In our state, a surveillance camera mounted on a shared boundary line and pointed at a neighboring property occupies an uncomfortable legal grey area, not clearly prohibited, not clearly permitted, deeply uncomfortable, potentially actionable under certain circumstances, depending on what the footage was used for and whether it captured areas with a reasonable expectation of privacy. I noted the installation date. I photographed the camera and its angle of coverage. I filed it. But something shifted after the camera went up, something that had nothing to do with legal strategy and everything to do with the texture of daily life. 3 families who had lived near our property for years, people my wife had traded garden vegetables with over the fence on summer afternoons, people whose children had ridden bikes with our children at the end of the gravel road, stopped making eye contact at the mailbox. One woman my wife had considered a genuine friend went from weekly phone calls to total silence without a word of explanation. No confrontation, no falling out, just absence arriving gradually and then completely. I found out why through a homeowner who approached me months later, after the litigation had begun, visibly uncomfortable with what she was about to say. Gerald had circulated a letter, not an official HOA communication, something more informal, more deniable. It suggested, in the careful, passive-aggressive language of someone who understands that written words create liability, that certain non-member properties adjacent to our community may present ongoing liability concerns that could affect our collective insurance ratings and long-term property values. He hadn't named me. He hadn't needed to. There was only one non-member property on that boundary. My wife told me about it one evening after the children were in bed, sitting at the kitchen table with both hands around a mug of tea that had gone cold while she was thinking about how to say what she needed to say. She told me quietly, the way people say things they've been carrying too long alone. "It's like they're trying to make us disappear," she said. "Like we don't belong here." I sat down across from her. Outside the kitchen window, the orchard was dark, the trees just visible against the sky, 60 years of root and branch and fruit that had never asked anyone's permission to exist. "I know," I said, "but we've been here since 1948. And I promise you, we're going to still be here when Gerald Marsh is a footnote." She looked at me for a long moment. Then she nodded once, and that was enough. It had always been enough between us. One nod, one moment of mutual understanding, no performance required. By early 2021, 5 cabins were complete and generating steady rental income that Gerald reported proudly in every HOA newsletter as evidence of the board's visionary amenity development strategy. Then he announced Phase 2. The February newsletter arrived in my mailbox with a color rendering on the front page, a tasteful illustration of a tree-lined gravel path connecting 8 small cabins, warm light in the windows, ornamental grasses along the edges, the whole thing labeled East Amenity Corridor, Phase 2, completing our natural retreat. Gerald's note to homeowners described cabins 6, 7, and 8 as the final phase of a project that has already generated over $200,000 in community revenue. I read that number very carefully. Then I opened my spreadsheet and cross-referenced it against my own tracking figures. He was right. He had made over $200,000 on my land. I called my surveyor that afternoon. Tom had been doing GPS boundary surveys in this county for 22 years, and he had the particular patience of someone who understands that precision matters more than speed. I explained what I needed: a complete GPS survey of my eastern boundary plotted against the HOA's recorded plat, accurate to the inch, documented for litigation. He came out on a Thursday, spent 4 hours walking the line with equipment that costs more than most cars, and sent me his report 2 weeks later. The report confirmed everything Ruth's title examination had established, but it added one detail that I had not fully anticipated. Cabin 8's planned foundation footprint extended 14 feet past the disputed strip and into my undisputed parcel, not the gap, not the ambiguous 0.3-acre strip, whose ownership was a matter of survey error and competing records. My parcel. The land whose ownership had been uncontested and unambiguous since the day my grandfather walked out of the county recorder's office in 1948. Gerald wasn't just building on disputed land anymore. He was building on land that was simply, clearly, unquestionably mine. I read that line in Tom's report 3 times. Then I opened the litigation folder and began organizing everything by exhibit number. 3 days after Cabin 8 broke ground, Gerald appeared at my front door. No hard hat. No clipboard. No contractor crew as an audience. Just Gerald in a pressed shirt, holding a folded document, wearing the careful expression of a man who has decided to be reasonable now that being unreasonable has become inconvenient. He told me the HOA wanted to resolve the boundary ambiguity proactively. He said they were prepared to purchase the disputed strip for $18,000. Fair market value for raw agricultural land, he said, as though he had done the math himself rather than having an appraiser do it for him. He said all outstanding fines would be forgiven as part of the agreement. Clean slate. Neighborly resolution. The easy way. And then, in the same even tone, he added, "Look, we can do this the easy way or we can do this the expensive way. Attorneys cost money." Just saying. I looked at him for a moment. Outside, behind him, I could see the framing of Cabin 8 going up at the edge of my orchard. I could see one of my apple trees, one my grandmother planted, standing about 20 feet from where his contractors were working. "Gerald," I said, "I am an attorney." A beat. A very specific beat, the kind that happens when a sentence lands somewhere a person wasn't expecting. "I'll review the offer and be in touch." He left. I closed the door, photographed the offer letter with my phone, wrote a 1-paragraph contemporaneous note describing the conversation in full, his exact words, my exact words, the date, the time, the fact that Cabin 8's foundation work had begun 3 days prior, and added everything to the litigation folder. Then I sat down at my desk and began drafting the complaint. 19 years of practice. 2 years of documentation. 1 folder, organized by exhibit number, sitting on my desktop. Gerald had told me attorneys cost money. He had no idea what he was about to find out. I filed on a Thursday morning in September 2021. Not from a courthouse steps moment, not with cameras or an audience or any of the theater that people imagine attaches to the moment a lawsuit begins. I filed electronically from my desk, in the same room where I had spent 2 years building the litigation folder, 1 certified letter and 1 time-stamped photograph at a time. I hit submit at 8:47 in the morning. The confirmation screen appeared. I closed the laptop, refilled my coffee, and went outside to walk the orchard. The trees were starting to turn. The apples my grandmother had planted were heavy on the branches, the way they get in late September when the nights go cold and the fruit deepens in color almost overnight. I walked the full length of the eastern boundary, all 190 feet of it, from the creek to the stone wall, and I thought about how long this land had been waiting for someone to say, officially and permanently, that it was ours. The wait was over. The legal action had 4 components, and each one had been constructed with the same deliberateness my grandfather had applied to the stone dam, piece by piece, fitted together, designed to hold against pressure. The first was a quiet title action. This is the legal mechanism courts use to resolve disputed land ownership with finality, not just settling the argument between two parties, but correcting the public record itself. A quiet title judgment doesn't just say who wins. It amends the plat. It instructs the county recorder to fix the error. It becomes the permanent recorded truth about who owns what, binding on every future buyer, every future surveyor, every future Gerald who might arrive with a blueprint and a hard hat and an assumption that nobody was paying attention. The second component was a trespass complaint. Straightforward, documented, supported by Tom's GPS survey, accurate to the inch. 8 structures on land that did not belong to the HOA. The legal theory was simple. The documentation was airtight. The third was the unjust enrichment claim, and this was the one that had required 2 years to build properly. Unjust enrichment holds that if you have benefited economically from something that was not yours, if you have made money from land you had no right to use, you owe that benefit to the person it actually belonged to. I had 31 months of cabin rental income tracked in my spreadsheet, cross-referenced against the HOA's own published rates and their member portal's availability records. I had obtained the HOA's business license filings through a public records request, which contained revenue disclosures that corroborated my tracking figures within a margin of less than 3%. The total came to $214,000. The fourth component was a harassment and retaliation claim under our state's HOA statute. 5 retaliatory violation notices issued against pre-existing conditions, 1 surveillance camera pointed at my property, 1 letter circulated to neighbours suggesting I was a liability concern, documented across 14 months of certified mail and time-stamped photographs, each piece of paper dated and organised by exhibit number. I named 2 defendants, Sunridge Commons HOA LLC and Gerald Marsh individually. The lis pendens was recorded the same morning the complaint was filed. A lis pendens, the Latin means suit pending, is a document recorded with the county that serves as a public notice to anyone who looks. This property is the subject of active litigation. Its practical effect is immediate and significant. It clouds the title. It means the HOA cannot sell, refinance, transfer, or further develop the disputed strip without court permission, because any lender or buyer conducting routine due diligence will see the notice and understand that the ownership of that land is actively contested in court. What I knew, and what Gerald did not yet know, was that the HOA had been in the middle of refinancing the clubhouse mortgage. The application had been submitted 6 weeks earlier. The bank's title review was scheduled for the week after I filed. The bank's title officer found the lis pendens on a Monday morning. She flagged it. Her supervisor called the HOA's attorney at 10:30. The attorney called the board treasurer. The treasurer called 3 board members in sequence. The third board member called Gerald. I know this chain of events because one of those board members described it to me afterward in the parking lot of the county courthouse in the way that people recount things they found both alarming and, in retrospect, grimly satisfying. Gerald, she said, had gone completely silent on the phone when he heard the phrase lis pendens. Not the silence of someone who doesn't know what it means. The silence of someone who knows exactly what it means and is rapidly calculating what it costs. It lasted almost 30 seconds. Then he said, "Get me a litigator." The deposition of Gerald Marsh took place on a Tuesday morning in January 2022 in the 3rd floor conference room of my retained attorney's office building, a room with a long table, institutional grey carpet, and the particular flat quiet of a space designed specifically for conversations that will be transcribed. I had retained outside counsel to manage the litigation for 2 reasons. The first was ethical. An attorney representing himself has a fool for a client, and I had spent too long building this case to let ego compromise the execution. The second was strategic. I wanted to sit across from Gerald without the cognitive load of also managing my own case. I wanted to be free to watch him. He arrived in a dark blazer and a collared shirt. No polo, no Hawa log. He had a leather portfolio that he set on the table in front of him with the deliberate placement of a man who has been coached to project organization. His attorney, retained through the HOA's insurance carrier, sat to his left. The court reporter sat at the end of the table, fingers poised. I sat directly across from Gerald and said nothing while the preliminaries were established. We spent the first 90 minutes on background, Gerald's election to the board, his role as president, the board's approval process for the East Amenity Corridor Plan, The contractor selection, the phasing of construction, standard groundwork, methodical and unremarkable, designed partly to establish the record and partly to let Gerald relax into the rhythm of answering questions he had prepared for. He was smooth. He had been well coached. He answered with the measured confidence of someone who has rehearsed. Then my attorney turned to the permits. Mr. Marsh, I'm showing you what's been marked as Plaintiff's Exhibits 14 through 18, the county construction permits for cabins 1 through 5, respectively. Can you confirm that the signature appearing on each of these documents is yours? Gerald looked at the permits. He took a moment, a professional moment, the kind you're taught to take so you don't appear to be answering too quickly. Yes, he said. That's my signature. And when you signed these permits, did you sign as an authorized officer of Sunridge Commons HOA LLC, meaning did you sign with the LLC identified as the permit applicant and yourself identified as its authorized representative? Or did you sign in your personal capacity, using your name and your title without designating the LLC as the principal? 4 seconds of silence. I counted them. Gerald glanced at his attorney. His attorney's expression did not change by a single degree. The trained neutrality of someone who has just heard a question they knew was coming and cannot help with. I signed as community president, Gerald said. Community president of the LLC? Or community president as a personal title you hold? His attorney objected to the form of the question. My attorney rephrased it 3 different ways over the next 6 minutes. Gerald's answers across all 3 versions did not improve his situation. He had signed personally. He had not designated the LLC as the permit applicant on a single one of 5 construction projects. His name, his title, no corporate entity identified. He had not known that distinction mattered. In that conference room, watching his face as the implications settled in, I could see the precise moment he understood that it did. The second turning point came 40 minutes later. Mr. Marsh, at the time construction began on cabins 1 through 5, were you personally aware that the 0.3-acre strip on which those structures were being built did not appear in Sunridge Commons HOA LLC's recorded chain of title? His attorney objected, calls for a legal conclusion, assumes facts not in evidence. My attorney acknowledged the objection, rephrased, and asked Gerald to answer to the best of his personal knowledge as the board president who had authorized the construction. We relied on our surveyor's plat, Gerald said. The plat identified that land as part of our Eastern Common area. We had no reason to question it. Which surveyor prepared that plat? Gerald gave a company name, a small firm that had handled the original 2008 survey for the developer who built Sunridge Commons. My attorney set a single document on the table, a state licensing board disciplinary record, printed from the public database. Mr. Marsh, are you aware that the principal surveyor at that firm had his professional license suspended in 2009, 1 year after your community's plat was filed, for errors in boundary measurement identified across 3 separate residential survey projects? Gerald looked at the document. He read it. I watched him read it, watched his eyes track down the page, watched him reach the suspension date, watched the colour shift in his face with the particular quality of a man who has just discovered that the ground he built everything on was never solid. I was not aware of that, he said. The room was quiet for a moment. Mr. Marsh, the HOA generated approximately $214,000 in rental revenue from the 5 cabins on this strip across 31 months of operation. As board president, were you aware that this income was being generated from land that did not appear in the HOA's recorded chain of title? We relied on our surveyor's plat, he said again. The same answer. Smaller this time. My attorney nodded, made a note, and moved on. Ruth's title report was submitted as the plaintiff's primary exhibit. 47 pages tracing every conveyance from 1948 forward, ending in a single paragraph that Gerald's attorneys could not dispute. The strip had never, by any legal mechanism, passed out of my grandfather's deed and into theirs. The drafting error had never been corrected. Not by court order, not by mutual agreement, not by anything. The HOA's insurance attorney reviewed the report before trial and sent a settlement offer, $60,000 for the strip, plus full waiver of all outstanding fines. I declined. Gerald's personal attorney, he had retained separate counsel by this point, which told me precisely how his insurance carrier viewed his individual exposure, sent a second offer within the week. $75,000, structured payment, full mutual release of all claims. I declined that one too. I had not spent 2 years building this case to exit it at a number Gerald's attorneys had calculated as the cheapest door out. I had a damage figure of $214,000, a 47-page title report, GPS coordinates to the inch, 5 retaliatory violation notices, and a letter in Gerald's own handwriting telling me we could do things the easy way or the expensive way. I needed the judge to read that letter. The hearing was held on a Wednesday morning in May, in a wood-panelled county courtroom with fluorescent lighting, a state flag that listed slightly to the left, and a portrait of a judge who had retired in 1987, hanging in a frame that had gone imperceptibly crooked sometime in the intervening decades. The kind of room where consequential things happen without ceremony. 11 HOA homeowners sat in the gallery. Gerald was at the defense table in his blazer, his personal attorney to his right, the HOA's insurance attorney to his left. He did not look at me when I walked in. I noticed that, and I noted it the way I note everything. The judge, a woman in her late 50s who carried the particular authority of someone who has heard every version of every argument and is interested only in what the documents say, called the proceeding to order and moved directly to substance. We presented in sequence the 1948 deed, the complete chain of title, Tom's GPS survey, the permit signed by Gerald personally, the rental revenue spreadsheet, Ruth's 47-page report, the 5 violation notices and my documented certified responses, the surveillance camera installation record, the neighbour letter, and last, placed on the exhibit list last, presented to the court last, given to the judge to read last, Gerald's June 2021 letter. The one he had hand-delivered to my front door 3 days after breaking ground on Cabin 8, telling me that attorneys cost money. At one point during the title chain presentation, the judge looked over the rims of her glasses at Gerald's HOA attorney and asked, in a tone that did not invite elaboration, "Counsel, does your client dispute the chain of title?" The attorney paused. It was the wrong kind of pause. Too long, too visible, the pause of someone choosing between 2 bad answers. "We dispute the significance of the survey discrepancy," he said finally. The judge set her pen down on the bench with a small, precise click. "That's not what I asked." She moved on. When she reached Gerald's letter, when she picked it up and read it in the full silence of the courtroom, the 11 homeowners in the gallery leaning almost imperceptibly forward, she read it completely. She set it down. She looked at Gerald, not at his attorney. At Gerald specifically, with the direct patient attention of someone who has just finished reading a document that told her everything she needed to know about the person who wrote it. "Mr. Marsh," she said with the measured quiet of someone who has never needed volume to make a point land, "it appears you were warned." Gerald said nothing. The room was very still for a moment, the particular stillness of a space in which something has just been decided and everyone present knows it, and no one speaks because speaking would diminish it. Outside the courthouse afterward, a man I recognized from the HOA neighborhood, older, careful in his posture, the kind of person who chooses his words before he says them, stopped me on the steps. He stood for a moment as if deciding whether to speak. Then he did. "I voted against the cabin project," he said, "in 2014. I was the only one." I thought of Patricia, the single dissenting vote in the board minutes, the woman who had asked for an independent survey verification and had been quietly removed from the board for asking. "I know," I said. "I read the minutes." He nodded slowly, extended his hand. I shook it. We stood there for a moment on the courthouse steps in the May morning light, 2 people on opposite sides of a fence that was about to come down, and then we went our separate ways. The judgment came down 3 weeks later. I was in my office when the filing notification hit my email. I read it once, standing at my desk. Then I sat down and read it again, slowly, the way you read something you want to make sure is real. It was real. The judge issued a full quiet title judgment in my favor. The 0.3-acre strip, all 190 feet of it, from the dry creek to the stone wall, everything in between, was confirmed as mine. The county recorder was ordered to correct the plat. The HOA's recorded boundary description was amended permanently. The drafting error my grandfather's deed had silently contradicted for 60 years was finally, officially corrected. It would never be ambiguous again. On the unjust enrichment claim, the judge awarded the full $214,000, 31 months of rental income generated on land the HOA had never owned. The HOA's insurance carrier, which had been funding the defense, immediately began the process of determining how much of that judgment they were obligated to cover. The answer, it turned out, was not all of it. Gerald Marsh, having signed 5 sets of construction permits in his personal capacity rather than as a properly designated officer of the LLC, was found jointly liable for $74,000 of the total judgment. His personal assets, his personal responsibility, the corporate veil he had never bothered to properly maintain, offered him exactly as much protection as it deserved to. The outstanding violation fines, $4,200, levied across 14 months of notices for a fence built in 1974, an orchard planted in 1961, a hand plough, a rooster, and a farmhouse that needed painting, were declared retaliatory and void. The HOA was ordered to reimburse the full amount with statutory interest. The 5 cabins on the strip were subject to a mandatory disposition order. The HOA had 180 days to either remove them at their own expense or purchase them from me at independently appraised fair market value. Gerald, I was told, pushed hard for removal. He wanted the cabins demolished. I suspect he thought it would feel like taking something back. The board overruled him. The cabins were appraised. I accepted the purchase price. It was the last decision Gerald Marsh made as HOA president. He resigned from the board 11 days after the judgment. He did not send a letter. He did not make a statement. He simply stopped showing up to meetings, to the community events he had organized for a decade, to the morning walks along the amenity corridor he had built with someone else's land. His HOA logo polo shirts, I imagine, went to the back of a closet. The $74,000 personal judgment required him to liquidate certain assets to satisfy the debt. I know this through the public record of the judgment lien, not through any pleasure in the details. But I will tell you this, the asset that went first, according to the county records, was a boat. A 22-foot bow rider he kept at a marina 20 minutes from the neighborhood. I note this not with satisfaction. I note it because Gerald at my front door in June 2021 had told me that attorneys cost money. He was correct. They do. So does building 8 cabins on land you don't own. The HOA's insurance carrier dropped their policy 6 weeks after the judgment. The clubhouse refinancing, the one that had been interrupted by the Ellis Pendens on the morning I filed, stalled completely while the board scrambled to find new coverage. 3 board members quietly circulated a petition among homeowners asking how the community had been exposed to a $250,000 judgment without a single independent title verification. Patricia, the woman who had asked exactly that question in 2014 and had been voted off the board for asking it, declined to comment when a homeowner approached her. I like to think she allowed herself at least a private moment. Over the following months, 3 HOA homeowners reached out to me individually, not through attorneys, just neighbors coming to a fence line or sending a note, saying some version of the same thing, that they were sorry for how things had gone, that they hadn't known, that they wished it had been different. I accepted each apology with 2 words. Thank you. That was enough. It was genuinely enough. I had not spent 2 years building that case because I wanted an enemy. I had built it because I wanted my land. There is a difference, and it matters. I used the settlement funds carefully. The stone dam my grandfather built by hand had been losing ground for years. The mortar between the rocks had gone soft in places, and every hard march I watched the creek push a little higher against it than I was comfortable with. I hired a mason that fall, and we spent 2 weeks repointing every joint, resetting 3 courses of stone that had shifted, and reinforcing the spillway channel. When we were done, it looked, my son said, like it would last another 100 years. I told him that was the idea. The farmhouse foundation, the original stone base my grandfather had laid in the late 1940s, got the same treatment. New mortar, reset corners, the front-facing stonework cleaned and repointed so that the house looked for the first time in my memory the way it must have looked when it was new. Solid. Deliberate. Built to stay. And the orchard. My grandmother had always said she meant to plant 40 more trees. Life had intervened, the way life does, and she had never gotten to them. She died with that intention still pending, which is the kind of thing that sits quietly in a family for decades, without anyone saying it out loud. I planted 40 trees that autumn. Apples mostly, with 4 pears and 2 new fig trees, 1 for each end of the eastern boundary. My wife and both children helped. We planted them in a line running the full length of the strip, land that was now permanently, irrevocably, correctly recorded as ours. Where the HOA's security camera post used to stand, my wife hung a wind chime. It rings on most mornings. I have grown to like the sound. The 0.3-acre strip is seeded now with clover and wildflowers. In the first summer after the judgment, my children played there constantly, running the length of it, lying in the grass, doing the things children do on land that feels safe and open and theirs. I watched them from the kitchen window one evening, the same window where I had stood 2 years earlier watching Gerald's bulldozer, and I thought about how completely different the same view can look depending on what you know. I pulled my grandfather's deed from my desk drawer. The original, handwritten, the ink gone brown at the edges, the county clerk's slanted cursive still perfectly legible after 75 years. I read the legal description aloud, quietly, to no one in particular. 190 feet along the eastern boundary, bounded by the dry creek to the north, the stone wall to the south, and everything in between. My daughter appeared in the doorway behind me. She was 8 years old and had inherited my mother's habit of materializing silently in rooms where you didn't expect her. "Why are the papers so old?" she asked. I looked at her, then at the deed, then at her again. "Because someone worked very hard a long time ago," I said, "to make sure this land stayed in our family." And it did. She considered this with the gravity children bring to things they sense are important, without fully understanding why. Then she nodded once and went back outside. I folded the deed carefully and put it back in the drawer. If you've been through something like this, if an HOA, a developer, or a neighbor has tried to take what's yours, through paperwork or pressure or the quiet assumption that you won't push back, tell me about it in the comments. I read every one. And if you're new here, subscribe. Because this channel exists for people who understand that property rights are not abstract legal concepts. They are the difference between a family keeping what they built and losing it to someone with a logo on their polo shirt. My grandfather bought this land with 7 years of wages. Nobody got to take it. Nobody ever will.